The President pro tempore. Would the sponsor then say that this bill repeals, by implication or as a consequence, the law he just cited for the protection of the child as contained in that code just mentioned, since this provides for stronger deterrence against child abuse and we have now a code for the protection of the child? Would that code be now amended by this act, if passed? Senator Lena. We specified in the bill, Mr. President, increase in penalties. That is one. But, of course, that is not everything included in the bill. There are other aspects like making it easier to prosecute these cases of pedophilia in our country. That is another aspect of the bill. The other aspects of the bill include the increase in the penalties on acts committed against children, and by definition, children are those below 15 years of age. So, it is an amendment to the Child and Youth Welfare Code, Mr. President. This is not an amendment by implication. We made direct reference to the articles in the revised Penal Code and in the articles in the Child and Youth Welfare Code that are amended because of the increase in penalties. Emphasis and underscoring supplied. Given the clear import of the above, that the legislature expressly named the provisions as sought to amend through RA 7610, the ponentia cannot now insist on an amendment by implication. The position that Section 5b, RA 7610 rendered Article 336 of the RPC inoperative when the victim is a child, despite the lack of a manifest intention to the effect as expressed in the letter of the said provision, is unavailing. Differently stated, an implied partial repeal cannot be insisted upon in the face of the express letter of the law. I therefore believe that any continued assertion that Section 5b of RA 7610 applies to any and all cases of acts of lasciviousness committed against children, whether under the context of being ex-osa or not, is not in accordance with the law itself. When Section 5b, RA 7610 applies, as demonstrated above, both literal and purposive tests, therefore, show that there is nothing in the language of the law or in the Senate deliberations that supports the conclusion that Section 5b, RA 7610 subsumes all instances of sexual abuse against children. Thus, for a person to be convicted of violating Section 5b, RA 7610, the following essential elements need to be proved. 1. The accused commits the act of sexual intercourse or lascivious conduct. 2. The said act is performed with a child exploited in prostitution or subjected to other sexual abuse, and 3. The child, whether male or female, is below 18 years of age. 43. The unique circumstances of the children exploited in prostitution or subjected to other sexual abuse, for which the provisions of RA 7610 are intended, are highlighted in this exchange. The presiding officer, Senator Mercado. Senator Pimentel. Senator Pimentel. Just this question, Mr. President, if the gentleman will allow. Will this amendment also affect the revised Penal Code provisions on seduction? Senator Lena. No, Mr. President. Article 336 of Act No. 3815 will remain unaffected by this amendment we are introducing here. As a backgrounder, the difficulty in the prosecution of so-called pedophiles can be traced to this problem of having to catch the malefactor committing the sexual act on the victim. And those in the law enforcement agencies and in the prosecution service of the government have found it difficult to prosecute. Because if an old person, especially a foreigner, is seen with a child with whom he has no relation, blood or otherwise, and they are just seen in a room and there is no way to enter the room and to see them in flagrante delicto, then it will be very difficult for the prosecution to charge or to hail to court these pedophiles. So, we are introducing into this bill, Mr. President, an act that is considered already an attempt to commit child prostitution. This, in no way, affects the revised Penal Code provision on acts of lasciviousness or qualified seduction. 44, emphasis and underscoring supplied. Bearing these in mind, there is no disagreement as to the first and third elements of Section 5b. The core of the discussion relates to the meaning of the second element, that the act of sexual intercourse or lascivious conduct is performed with a child exploited in prostitution or subjected to other sexual abuse. To my mind, A person can only be convicted of violation of Article 336 in relation to Section 5b, upon allegation and proof of the unique circumstances of the child, that he or she is exploited in prostitution or subject to other sexual abuse. In this light, I quote in agreement Justice Carpio's dissenting opinion in Olivares v. Court of Appeals 45. Section 5 of RA 7610 deals with a situation where the acts of lasciviousness are committed on the child already either exploited in prostitution or subjected to other sexual abuse. Clearly, the acts of lasciviousness committed on the child are separate and distinct from the other circumstance, that the child is either exploited in prostitution or subjected to other sexual abuse. XXXX. Section 5 of RA 7610 penalizes those who commit the act of sexual intercourse or lascivious conduct with a child exploited in prostitution or subjected to other sexual abuse. The act of sexual intercourse or lascivious conduct may be committed on a child already exploited in prostitution, whether the child engages in prostitution for profit or someone coerces her into prostitution against her will. The element of profit or coercion refers to the practice of prostitution, not to the sexual intercourse or lascivious conduct committed by the accused. A person may commit acts of lasciviousness even on a prostitute, as when a person mashes the private parts of a prostitute against her will. The sexual intercourse or act of lasciviousness may be committed on a child already subjected to other sexual abuse. The child may be subjected to such other sexual abuse for profit or through coercion, as when the child is employed or coerced into pornography. A complete stranger, through force or intimidation, may commit acts of lasciviousness on such child in violation of Section 5 of RA 7610. The phrase other sexual abuse plainly means that the child is already subjected to sexual abuse other than the crime for which the accused is charged under Section 5 of RA 7610. The other sexual abuse is an element separate and distinct from the acts of lasciviousness that the accused performs on the child. The majority opinion admits this when it enumerates the second element of the crime under Section 5 of RA 7610. That the lascivious act is performed with a child XXX subjected to other sexual abuse. 46. Emphasis and underscoring supplied. Otherwise stated, in order to impose the higher penalty provided in Section 5b as compared to Article 336, it must be alleged and proved that the child, 1, for money, profit, or any other consideration or, 2, due to the coercion or influence of any adult, syndicate or group, indulges in sexual intercourse or lascivious conduct. In People v. Abloh 47, Abloh, one of the reasons the accused was convicted of rape by sexual assault and acts of lasciviousness, as penalized under the RPC and not under Section 5b, was because there was no showing of coercion or influence required by the second element. The court ratiocinated. In Olivares v. Court of Appeals, we explained that the phrase, other sexual abuse in the above provision covers not only a child who is abused for profit, but also one who engages in lascivious conduct through the coercion or intimidation by an adult. In the latter case, there must be some form of compulsion equivalent to intimidation which subdues the free exercise of the offended party's will. In the present case, the prosecution failed to present any evidence showing that force or coercion attended Abloh's sexual abuse on AAA. The evidence reveals that she was asleep at the time these crimes happened and only awoke when she felt her breasts being fondled. Hence, she could have not resisted Abloh's advances as she was unconscious at the time it happened. In the same manner, there was also no evidence showing that Abloh compelled her, or cowed her into silence to bear his sexual assault, after being roused from sleep. Neither is there evidence that she had the time to manifest conscious lack of consent or resistance to Abloh's assault. 48. Emphasis and underscoring supplied. The point of the foregoing is simply this: Articles 266A and 336 of the RPC remain as operative provisions, and the crime of rape and acts of lasciviousness continue to be crimes separate and distinct from a violation under Section 5b, RA 7610. The legislative intent to have the provisions of RA 7610 to operate side by side with the provisions of the RPC, and a recognition that the latter remain effective, can be gleaned from Section 10 of the law, which again I quote. SEC 10. Other acts of neglect, abuse, cruelty or exploitation and other conditions prejudicial to the child's development. A. Any person who shall commit any other acts of child abuse, cruelty or exploitation or be responsible for other conditions prejudicial to the child's development including those covered by Article 59 of Presidential Decree No. 603, as amended, but not covered by the Revised Penal Code, as amended, shall suffer the penalty of prison mayor in its minimum period. Emphasis and underscoring. This is confirmed by Senator Lina in his sponsorship speech of RA 7610, thus. Senator Lina. XXX. XXXX. Senate Bill No. 1209, Mr. President, is intended to provide stiffer penalties for abuse of children and to facilitate prosecution of perpetrators of abuse. It is intended to complement provisions of the Revised Penal Code where the crimes committed are those which lead children to prostitution and sexual abuse, trafficking in children and use of the young in pornographic activities. These are the three areas of concern which are specifically included in the United Nations Convention on the Rights of the Child. As a signatory to this convention, to which the Senate concurred in 1990, our country is required to pass measures which protect the child against these forms of abuse. XXXX. Mr. President, this bill on providing higher penalties for abusers and exploiters, setting up legal presumptions to facilitate prosecution of perpetrators of abuse, and complementing the existing penal provisions of crimes which involve children below 18 years of age is a part of a national program for protection of children. XXXX. Mr. President, subject to perfecting amendments, I am hopeful that the Senate will approve this bill and thereby add to the growing program for special protection of children and youth. We need this measure to deter abuse. We need a law to prevent exploitation. We need a framework for the effective and swift administration of justice for the violation of the rights of children. 49, emphasis and underscoring supplied. It is thus erroneous to rule that RA 7610 applies in each and every case where the victim is a minor although he or she was not proved, much less alleged, to be a child exploited in prostitution or subjected to other sexual abuse. I invite the members of the court to go back to the mindset and ruling adopted in ABLO where it was held that since RA number 7610 is a special law referring to a particular class in society, the prosecution must show that the victim truly belongs to this particular class to warrant the application of the statute's provisions. Any doubt in this regard we must resolve in favor of the accused. 50. There is no question that, in a desire to bring justice to child victims of sexual abuse, the court has, in continually applying the principles laid down in Dimicata, Quimville, and Coyili, sought the application of a law that imposes a harsher penalty on its violators. However, as noble as this intent is, it is fundamentally unsound to let the penalty determine the crime. To borrow a phrase, this situation is letting the tail wag the dog. To be sure, it is the acts committed by the accused, and the crime as defined by the legislature, not the concomitant penalty, which determines the applicable law in a particular set of facts. As the former Second Division of the Court in People v. Ejercito, 51 a case penned by Justice Perlas Burnham and concurred in by the ponente, correctly held. Neither should the conflict between the application of Section 5b of RA 7610 and RA 8353 be resolved based on which law provides a higher penalty against the accused. The superseding scope of RA 8353 should be the sole reason of its prevalence over Section 5b of RA 7610. The higher penalty provided under RA 8353 should not be the moving consideration, given that penalties are merely accessory to the act being punished by a particular law. The term penalty is defined as punishment imposed on a wrongdoer usually in the form of imprisonment or fine. Punishment imposed by lawful authority upon a person who commits a deliberate or negligent act. Given its accessory nature, once the proper application of a penal law is determined over another, then the imposition of the penalty attached to that act punished and the prevailing penal law only follows as a matter of course. In the final analysis, it is the determination of the act being punished together with its attending circumstances, and not the gravity of the penalty ancillary to the punished act, which is the key consideration in resolving the conflicting applications of two penal laws. XXXX. Likewise, it is apt to clarify that if there appears to be any rational dissonance or perceived unfairness in the imposable penalties between two applicable laws, say for instance, that a person who commits rape by sexual assault under Article 266A in relation to Article 266B of the RPC, as amended by RA 8353, is punished less than a person who commits lascivious conduct against a minor under Section 5b of RA 7610, then the solution is through remedial legislation and not through judicial interpretation. It is well settled that the determination of penalties is a policy matter that belongs to the legislative branch of government. Thus, however compelling the dictates of reason might be, our constitutional order proscribes the judiciary from adjusting the gradations of the penalties which are fixed by Congress through its legislative function. As Associate Justice Diosdado M. Peralta had instructively observed in his opinion in Cali. Curiously, despite the clear intent of RA 7610 to provide for stronger deterrence and special protection against child abuse, the penalty, reclusion temporal medium, when the victim is under 12 years old is lower compared to the penalty, reclusion temporal medium to reclusion perpetua, when the victim is 12 years old and below 18. The same holds true if the crime of acts of lasciviousness is attended by an aggravating circumstance or committed by persons under Section 31, Article 12 of RA 7610, in which case, the imposable penalty is reclusion perpetua. In contrast, when no mitigating or aggravating circumstance attended the crime of acts of lasciviousness, the penalty therefore when committed against a child under 12 years old is aptly higher than the penalty when the child is 12 years old and below 18. This is because, applying the indeterminate sentence law, the minimum term in the case of the younger victim shall be taken from reclusion temporal minimum, whereas the minimum term in the case of the older victims shall be taken from prison mare medium to reclusion temporal minimum. It is a basic rule in statutory construction that what courts may correct to reflect the real and apparent intention of the legislature are only those which are clearly clerical errors or obvious mistakes, omissions, and misprints, but not those due to oversight, as shown by a review of extraneous circumstances, where the law is clear, and to correct it would be to change the meaning of the law. To my mind, a corrective legislation is the proper remedy to address the noted incongruent penalties for acts of lasciviousness committed against a child. 52, additional emphasis and underscoring supplied. Therefore, while I identify with the court in its desire to impose a heavier penalty for sex offenders who victimize children, the said crimes being undoubtedly detestable, the court cannot arrogate unto itself a power it does not have. Again, the court's continuous application of RA 7610 in all cases of sexual abuse committed against minors is, with due respect, an exercise of judicial legislation which it simply cannot do. At this point, it is important to point out that, as a result of this recurrent practice of relating the crime committed to RA 7610 in order to increase the penalty, the accused's constitutionally protected right to due process of law is being violated. An essential component of the right to due process in criminal proceedings is the right of the accused to be sufficiently informed of the cause of the accusation against him. This is implemented through Rule 110, Section 9 of the Rules of Court, which states, SEC 9. Cause of the accusation. The acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must be stated in ordinary and concise language and not necessarily in the language used in the statute but in terms sufficient to enable a person of common understanding to know what offense is being charged as well as its qualifying and aggravating circumstances and for the court to pronounce judgment. It is fundamental that every element of which the offense is composed must be alleged in the information. No information for a crime will be sufficient if it does not accurately and clearly allege the elements of the crime charged. 53 The law essentially requires this to enable the accused suitably to prepare his defense, as he is presumed to have no independent knowledge of the facts that constitute the offense. 54 From this legal backdrop, it may then be said that convicting an accused and relating the offenses to RA 7610 to increase the penalty when the information does not state that the victim was a child engaged in prostitution or subjected to sexual abuse constitutes a violation of an accused's right to due process. The Ponentia counters that, contrary to the view of Justice Kaguya, there is likewise no such thing as a recurrent practice of relating the crime committed to RA number 7610 in order to increase the penalty, which violates the accused's constitutionally protected right to due process of law. 55. Yet, no matter the attempts to deny the existence of such practice, the inconsistencies in the Ponentia itself demonstrate that its conclusions are driven by the desire to apply whichever law imposes the heavier penalty in a particular scenario. For instance, when discussing the applicable law when the act done by the accused constitutes sexual intercourse, the Ponentia has this discussion on the difference between the elements of force or intimidation and rape under the RPC, on one hand, and coercion or influence under Section 5b of RA 7610, on the other. In Quimville, it was held that the term coercion or influence is broad enough to cover or even synonymous with the term force or intimidation. Nonetheless, it should be emphasized that coercion or influence is used in Section 5 of RA number 7610 to qualify or refer to the means through which any adult, syndicate or group compels a child to indulge in sexual intercourse. On the other hand, the use of money, profit or any other consideration is the other mode by which a child indulges in sexual intercourse, without the participation of any adult, syndicate or group. In other words, coercion or influence of a child to indulge in sexual intercourse is clearly exerted not by the offender whose liability is based on Section 5b of RA number 7610 for committing sexual act with a child exploited in prostitution or other sexual abuse. Rather, the coercion or influence is exerted upon the child by any adult, syndicate, or group whose liability is found under Section 5a for engaging in, promoting, facilitating, or inducing child prostitution, whereby sexual intercourse is the necessary consequence of the prostitution. XXXX. As can be gleaned above, force, threat or intimidation is the element of rape under the RPC, while due to coercion or influence of any adult, syndicate or group is the operative phrase for a child to be deemed exploited in prostitution or other sexual abuse, which is the element of sexual abuse under Section 5b of RA number 7610. The coercion or influence is not the reason why the child submitted herself to sexual intercourse, but it was utilized in order for the child to become a prostitute. XXX. XXXX. Therefore, there could be no instance that an information may charge the same accused with the crime of rape where force, threat or intimidation is the element of the crime under the RPC, and at the same time violation of Section 5b of RA number 7610 where the victim indulged in sexual intercourse because she is exploited in prostitution either for money, profit or any other consideration or due to coercion or influence of any adult, syndicate or group. The phrase which qualifies a child to be deemed exploited in prostitution or other sexual abuse as an element of violation of Section 5b of RA number 7610.56, emphasis and underscoring supplied, emphasis in the original omitted. The Ponentia, however, refuses to apply the above analysis when the act constitutes sexual assault or lascivious conduct. It merely reiterates the Dimikata ruling, and again anchors its conclusion on the policy of the state to provide special protection to children. The Ponentia explains. Third, if the charge against the accused where the victim is 12 years old or below is sexual assault under paragraph 2, Article 266A of the RPC, then it may happen that the elements thereof are the same as that of lascivious conduct under Section 5b of RA number 7610. because the term lascivious conduct includes introduction of any object into the genitalia, anus or mouth of any person. In this regard, we held indemnicated that in instances where a lascivious conduct committed against a child is covered by RA number 7610 and the act is likewise covered by sexual assault under paragraph 2, article 266A of the RPC, punishable by prison mayor, the offender should be held liable for violation of section 5B of RA number 7610, punishable by reclusion temporal medium, consistent with the declared policy of the state to provide special protection to children from all forms of abuse, neglect, cruelty, exploitation and discrimination, and other conditions prejudicial to their development. XXX 57. In another part of the Ponentia, it partly concedes yet insists on its point, again by invoking the legislative intent behind the law. Thus, Justice Kaguya is partly correct. Section 5B of RA number 7610 is separate and distinct from common and ordinary acts of lasciviousness under Article 336 of the RPC. However, when the victim of such acts of lasciviousness is a child, as defined by law, we hold that the penalty is that provided for under Section 5B of RA number 7610, that is, reclusion temporal medium in case the victim is under 12 years old, and reclusion temporal medium to reclusion perpetual when the victim is between 12 years old or under 18 years old or above 18 under special circumstances, and not merely prison, correctional under Article 336 of the RPC. Our view is consistent with the legislative intent to provide stronger deterrence against all forms of child abuse, and the evil sought to be avoided by the enactment of RA number 7610, which was exhaustively discussed during the committee deliberations of the House of Representatives. 58. Clear from the foregoing is that the Ponentia is willing to apply the inherent differences between the provisions of the RPC and RA 7610 when it comes to rape by sexual intercourse, and it is because the RPC imposes the heavier penalty of reclusion perpetua compared with the reclusion temporal medium to reclusion perpetua of Section 5B, RA 7610. It is unwilling, however, to extend the same understanding of the differences between the provisions of the RPC and RA 7610, and in the process contradicts itself, when the act constitutes sexual assault, acts of lasciviousness or lascivious conduct for the reason that the RPC punishes the said acts with only prison correctional 59 or prison mayor. 60. Another instance in the Ponentia that reveals that the penalty imposed is the primordial consideration in the choice of applicable law is the discussion on whether RA 8353 has superseded RA 7610. In the earlier part of the Ponentia, it says, records of committee and plenary deliberations of the House of Representatives, and of the deliberations of the Senate, as well as the records of bicameral conference committee meetings, further reveal no legislative intent for RA number 8353 to supersede Section 5B of RA number 7610. XXX while RA number 8353 contains a generic repealing and amendatory clause, the records of the deliberation of the legislature are silent with respect to sexual intercourse or lascivious conduct against children under RA number 7610. Particularly those who are 12 years old or below 18, or above 18 but are unable to fully take care or protect themselves from abuse, neglect, cruelty, exploitation or discrimination because of a physical or mental disability or condition. 61, emphasis and underscoring supplied. Despite the clear pronouncement of the Ponentia quoted above that RA 8353 did not supersede RA 7610, it would later on say, XXX indeed, while RA number 7610 is a special law specifically enacted to provide special protection to children from all forms of abuse, neglect, cruelty, exploitation and discrimination and other conditions prejudicial to their development, we hold that it is contrary to the legislative intent of the same law if the lesser penalty, reclusion temporal medium to reclusion perpetua, under Section 5B thereof would be imposed against the perpetrator of sexual intercourse with a child 12 years of age or below 18. Article 266A, Paragraph 1a in relation to Article 266b of the RPC, as amended by RA No. 8353, is not only the more recent law, but also deals more particularly with all rape cases, hence, its short title the Anti-Rape Law of 1997. RA No. 8353 upholds the policies and principles of RA No. 7610, and provides a stronger deterrence and special protection against child abuse, as it imposes a more severe penalty of reclusion perpetua under Article 266b of the RPC, or even the death penalty if the victim is, 1, under 18 years of age and the offender is a parent, ascendant, step-parent, guardian, relative by consanguinity or affinity within the third civil degree, or common-law spouses of the parent of the victim, or, 2, when the victim is a child below 7 years old. It is basic in statutory construction that in case of irreconcilable conflict between two laws, the later enactment must prevail, being the more recent expression of legislative will. Indeed, statutes must be so construed and harmonized with other statutes as to form a uniform system of jurisprudence, and if several laws cannot be harmonized, the earlier statute must yield to the later enactment, because the later law is the latest expression of the legislative will. Hence, Article 266b of the RPC must prevail over Section 5b of RA No. 7610.62, emphasis and underscoring supplied. It is again plainly evident from the above that the conclusion is heavily influenced by the corresponding penalties contained in the respective laws. It is apparent, therefore, that the ponentia's choice of applicable law is primarily driven by the penalty imposed, all in the name of the state's policy to provide special protection to children. However, this would be in clear disregard of the right of the accused to be punished only to the extent that the law imposes a specific punishment on him. This practice, without doubt, violates the rights of the accused in these cases. In Dimikada, for example, one of the three oft-cited cases of the ponentia in reaching its conclusions, the crime was related to RA 7610 to increase the penalty even if the information in the said case did not even mention the said law nor was there any allegation that the victim was epsosa. The information in Dimikada states that on or about the 24th day of September 2005, in the city of Las Piñas, Philippines, and within the jurisdiction of this honorable court, the above-named accused, with lewd designs, did then and there willfully, unlawfully and feloniously commit a lascivious conduct upon the person of one AAA, who was then a 16-year-old minor, by then and there embracing her, touching her breast and private part against her will and without her consent, and the act complained of is prejudicial to the physical and psychological development of the complainant. 63. The information filed in this case likewise did not specify that the victim was exploited in prostitution or subjected to other sexual abuse, and in fact indicated force and intimidation as the mode of committing the crime, which, by the opponent's arguments above, triggers the application of the RPC, not Section 5b of RA 7610. The information reads that sometime in the month of September 2011, at XXX, and within the jurisdiction of this honorable court, the above-named accused, by means of force, intimidation and with abuse of superior strength forcibly laid complainant AAA, a 9-year-old minor in a cemented pavement, and did then and there willfully, unlawfully and feloniously inserted his finger into the vagina of the said AAA, against her will and consent. 64, emphasis and underscoring supplied. Again, by the ponentia's pronouncements, that, 1, there could be no instance that an information may charge the same accused with the crime of rape where force, threat or intimidation is the element of the crime under the RPC, and at the same time violation of Section 5b of RA No. 7610, 65 and, 2, that coercion or influence of a child to indulge in sexual intercourse is clearly exerted not by the offender whose liability is based on Section 5b of RA No. 7610 for committing sexual act with a child exploited in prostitution or other sexual abuse. Rather, the coercion or influence is exerted upon the child by any adult, syndicate, or group whose liability is found under Section 5A, 66, then the accused appellant in this case should be convicted only of sexual assault under Article 266A2 of the RPC, punishable by prison mayor, instead of sexual assault, in relation to Section 5B, RA 7610, punishable by reclusion temporal medium, as the Ponentia did. It is true that because of Demicata and other similar cases, many prosecutors have opted to put the phrase in relation to Republic Act No. 7610 in informations they file with the courts, just like in this case, concerning rape or sexual abuse. This practice, however, does not mean that the violation of due process has stopped. In Cancerin v. People, 67, the court stressed, "The court is not unmindful of the rule that the real nature of the criminal charge is determined, not from the caption or preamble of the information nor from the specification of the law alleged to have been violated, these being conclusions of law, but by the actual recital of facts in the complaint or information." In the case of Domingo v. Rila, it was written, "What is controlling is not the title of the complaint, nor the designation of the offense charged or the particular law or part thereof allegedly violated, these being mere conclusions of law made by the prosecutor, but the description of the crime charged and the particular facts therein recited. The acts or omissions complained of must be alleged in such form as is sufficient to enable a person of common understanding to know what offense is intended to be charged, and enable the court to pronounce proper judgment. No information for a crime will be sufficient if it does not accurately and clearly allege the elements of the crime charged. Every element of the offense must be stated in the information. What facts and circumstances are necessary to be included therein must be determined by reference to the definitions and essentials of the specified crimes. The requirement of alleging the elements of a crime in the information is to inform the accused of the nature of the accusation against him so as to enable him to suitably prepare his defense. 68, additional emphasis and underscoring supplied. To recall, the test for sufficiency of an information is that it must state the facts constituting the offense in a manner that would enable a person of common understanding to know what offense was intended to be charged. 69 Hence, the phrase in relation to Republic Act No. 7610 in criminal informations, much like in the one filed in this case, does not cure the defect in the said informations. Again, it is my view that criminal informations, to be considered under the purview of Section 5B, RA 7610, must state the child victim is exploited in prostitution or subjected to other sexual abuse and allege the particulars. In addition, even if it was alleged in the information that the act is contrary to, or in violation of, RA 7610, if, during the trial, it was not proved that the victim was a child engaged in prostitution or subjected to other sexual abuse, it would be error to convict the said accused under Section 5B, RA 7610. This is because it is well established that the following are the elements of the crime. 1. The accused commits the act of sexual intercourse or lascivious conduct. 2. The said act is performed with a child exploited in prostitution or subjected to other sexual abuse, and 3. The child, whether male or female, is below 18 years of age. 70, emphasis and underscoring supplied, emphasis in the original omitted. It cannot really be gainsaid that the second element of the crime defined in RA 7610 requires that the child victim be one that is exploited in prostitution or subjected to other sexual abuse, and not just simply any child. In the present case, for instance, the information states that the act committed by the accused was, contrary to Article 266A, Par. 2 of the Revised Penal Code in relation to RA 7610-71, and yet, it was not proved, much less alleged, that the victim was engaged in prostitution or was subjected to other sexual abuse. According to the Ponentia, the victim AAA was merely peeling corn with her cousin when the accused, who lived adjacent to her grandmother's house, approached her and opened her legs, and inserted his finger into her private part. 72 There is nothing in the Ponentia from which it could be reasonably inferred that AAA was engaged in prostitution or subjected to other sexual abuse, and yet, The accused Salvador Tulagan is being adjudged guilty of sexual assault under Paragraph 2, Article 266A of the Revised Penal Code, in relation to Section 5B of Republic Act No. 7610. 73. When the statute speaks unequivocally, there is nothing for the courts to do but to apply it. The accused in this case is clearly guilty only of sexual assault, defined and penalized under Article 266A, Par. 2 of the RPC, as amended by RA 8353, and not in relation to RA 7610. To reiterate, RA 7610 and the RPC, as amended by RA 8353, have different spheres of application. They exist to complement each other such that there would be no gaps in our criminal laws. They were not meant to operate simultaneously in each and every case of sexual abuse committed against minors. In this connection, I agree with the Ponentia as it lays down the following guidelines in determining which law should apply when the victim is a minor and the sexual act done constitutes rape by sexual intercourse. Even if the girl who is below 12 years old or is demented consents to the sexual intercourse, it is always a crime of statutory rape under the RPC, and the offender should no longer be held liable under RA number 7610. XXX. XXXX. If the victim who is 12 years old or less than 18 and is deemed to be a child exploited in prostitution and other sexual abuse because she agreed to indulge in sexual intercourse for money, profit or any other consideration or due to coercion or influence of any adult, syndicate or group, then the crime could not be rape under the RPC, because this no longer falls under the concept of statutory rape, and there was consent. That is why the offender will now be penalized under Section 5B, RA number 7610, and not under Article 335 of the RPC, now Article 266A. But if the said victim does not give her consent to sexual intercourse in the sense that the sexual intercourse was committed through force, threat or intimidation, the crime is rape under Paragraph 1, Article 266A of the RPC. However, if the same victim gave her consent to the sexual intercourse, and no money, profit, consideration, coercion or influence is involved, then there is no crime committed, except in those cases where force, threat or intimidation as an element of rape is substituted by moral ascendancy or moral authority, like in the cases of incestuous rape, and unless it is punished under the RPC as qualified seduction under Article 337 or simple seduction under Article 338. 74. Verily, in the above guidelines of the Ponentia, the court has already taken the right steps forward in streamlining which law is applicable in a particular set of facts. It is thus my view to extend the same set of guidelines not just in cases where the act done constitutes rape by sexual intercourse, but also in cases where the act done constitutes rape by sexual assault or acts of lasciviousness. Respectfully, the objective of the Ponentia to finally reconcile the seemingly conflicting laws and the resulting confusing state of jurisprudence would better be achieved if the court adopts the foregoing understanding. To illustrate, if the court decides to adopt the foregoing, the proposed table by the Ponentia would look like this. Acts done by the accused consist of: crime committed if the victim is under 12 years old or demented. Crime committed if the victim is 12 years old or older but below 18, or is 18 years old but under special circumstances 75. Crime committed if victim is 18 years old and above. Acts of lasciviousness. Acts of lasciviousness under Article 336 of the RPC. Penalty, Brazen correctional. If committed against a child exploited in prostitution or subjected to other sexual abuse, the crime committed would still be acts of lasciviousness but the penalty would be reclusion temporal in its medium period in accordance with Section 5B of RA 7610. Acts of lasciviousness under Article 336 of the RPC. Penalty, Brazen correctional. If committed against a child exploited in prostitution or subjected to other sexual abuse, the crime committed would be lascivious conduct under Section 5b of RA 7610 and the penalty would be reclusion temporal in its medium period to reclusion perpetua. Acts of lasciviousness under Article 336 of the RPC. Penalty, prison correctional. Sexual assault. Sexual assault under Article 266A2 of the RPC. Penalty, prison mayor. If committed against a child exploited in prostitution or subjected to other sexual abuse, it would still be sexual assault but the penalty would be reclusion temporal in its medium period in accordance with Section 5b of RA 7610. Sexual assault under Article 266A2 of the RPC. Penalty, prison mayor. If committed against a child exploited in prostitution or subjected to other sexual abuse, the crime would be lascivious conduct under Section 5b of RA 7610 and the penalty would be reclusion temporal in its medium period to reclusion perpetua. Sexual assault under Article 266A2 of the RPC. Penalty, prison mayor. Carnal knowledge, rape by sexual intercourse. Rape under Article 266A1 of the RPC. Penalty, reclusion perpetua, except when the victim is below 7 years old, in which case death penalty shall be imposed. Rape under Article 266A1 of the RPC. Penalty, reclusion perpetua. If committed against a child exploited in prostitution or subjected to other sexual abuse, the crime would be sexual abuse under Section 5b of RA 7610 and the penalty would be reclusion temporal in its medium period to reclusion perpetua. Rape under Article 266A1 of the RPC. Penalty, reclusion perpetua. On the supposed repeal of Article 336 of the Revised Penal Code, I would also like to take this opportunity to offer my point of view on the points raised by Justice Marvick MVF Leonin in his separate opinion. Justice Leonin argues that the enactment of RA 8353 rendered ineffective the provision on acts of lasciviousness in the RPC. According to him, Article 336 of the RPC punishes any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, and since the preceding article referred to was the old provision on rape supposedly repealed 76 by RA 8353, he then concludes that Article 336 of the RPC is no longer operative. I respectfully disagree with my esteemed colleague. It is well settled that repeals by implication are not favored. A law will only be declared impliedly repealed when it is manifest that the legislative authority so intended, 77, or unless it is convincingly and unambiguously demonstrated that the subject laws or orders are clearly repugnant and patently inconsistent that they cannot coexist. 78 In the absence of such showing, every effort must be used to make all acts stand, and the later act will not operate as a repeal of the earlier one, if by any reasonable construction they can be reconciled. 79 As the court said in Mekano v. Co. 80. Repeal by implication proceeds on the premise that where a statute of later date clearly reveals an intention on the part of the legislature to abrogate a prior act on the subject, that intention must be given effect. Hence, before there can be a repeal, there must be a clear showing on the part of the lawmaker that the intent in enacting the new law was to abrogate the old one. The intention to repeal must be clear and manifest, otherwise, at least, as a general rule, the later act is to be construed as a continuation of, and not a substitute for, the first act, and will continue so far as the two acts are the same from the time of the first enactment. 81 Emphasis and underscoring supplied. In the present case, I do not discern any clear intent on the part of the legislature to repeal the crime of acts of lasciviousness in enacting RA 8353. Justice Leonin's argument is based on the premise that Article 335 was repealed by RA 8353. I submit that the premise is misplaced because, in fact, the provision penalizing the act of rape was only renumbered to reflect the paradigm shift introduced by RA 8353 in treating rape as a crime against persons instead of merely a crime against chastity, and amended to reflect the policy changes with regard to how it is committed and the circumstances which may aggravate the same. I find nothing in RA 8353 to reasonably infer that it meant to affect the crime of acts of lasciviousness apart from the renumbering of Article 335 to Articles 266A to 266D. To me, this is not the clear and manifest intention to repeal required by jurisprudence. Thus, every effort must be exerted to reconcile the provisions and make all acts stand. Thus, it is my view that Article 336 is not rendered incomplete and ineffective since its elements can still be completed by simply construing the phrase preceding article to mean Article 266A, since the same act remains to be punished. To emphasize, the intention to punish the crime of acts of lasciviousness remains, and a minor modification in article numbers does not operate to revoke the said intention. In further arguing for the ineffectivity of Article 336, Justice Leonen reasons that, in any case, the ineffectivity of Article 336 does not preclude acts of lasciviousness from being punishable under different laws such as Republic Act No. 7610, or the Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act, or Republic Act No. 9262. Or the Anti-Violence Against Women and Their Children Act of 2004. These laws, likewise, carry more severe penalties than Article 336, providing better protection for victims of lascivious acts not constituting rape. 82. Again, I differ with my learned colleague. With due respect, I cannot subscribe to the foregoing ratiocination because, to reiterate, RA 7610 was enacted only to address a specific set of victims, as it only covers children exploited under prostitution or subjected to other sexual abuse. But even if we accept, for the sake of argument, that RA 7610 covers all types of sexual abuse committed against any child, without qualification, I am still unconvinced by the argument, for such construction would create a huge gap in our criminal laws that would protect women victims of acts of lasciviousness who are either, 1, no longer minors, or, 2, were not abused by a person with whom they have or had a sexual or dating relationship. To illustrate, if the court decides to adopt Justice Leonen's proposed construction, there would be no crime committed in case a random stranger touches a 19-year-old woman's private parts without her consent. On the distinction between rape by penile penetration and other forms of sexual abuse, Justice Leonen reiterates his view as expressed in Coeli that, the persistence of an archaic understanding of rape relates to our failure to disabuse ourselves of the notion that carnal knowledge or sexual intercourse is merely a reproductive activity. 83. In driving home his point, he quotes his decision in People v. Quindos, 84, which states, "The classifications of rape in Article 266A of the Revised Penal Code are relevant only insofar as these define the manners of commission of rape. However, it does not mean that one manner is less heinous or wrong than the other. Whether rape is committed by non-consensual carnal knowledge of a woman or by insertion of the penis into the mouth of another person, the damage to the victim's dignity is incalculable. Child sexual abuse in general has been associated with negative psychological impacts such as trauma, sustained fearfulness, anxiety, self-destructive behavior, emotional pain, impaired sense of self, and interpersonal difficulties. Hence, one experience of sexual abuse should not be trivialized just because it was committed in a relatively unusual manner. The prime purpose of a criminal action is to punish the offender in order to deter him and others from committing the same or similar offense, to isolate him from the society, reform and rehabilitate him, or, in general, to maintain social order. Crimes are punished as retribution so that society would understand that the act punished was wrong. Imposing different penalties for different manners of committing rape creates a message that one experience of rape is relatively trivial or less serious than another. It attaches different levels of wrongfulness to equally degrading acts. Rape, in whatever manner, is a desecration of a person's will and body. In terms of penalties, treating one manner of committing rape as greater or less in heinousness than another may be of doubtful constitutionality. 85. While I fully understand the underlying considerations of Justice Leonen's viewpoint, I respectfully disagree with his proposed approach. I agree with Justice Leonen that, a woman who was raped through insertion of a finger does not suffer less than a woman who was raped by penile penetration. 86. I likewise concur with the following statements of Justice Leonen. Sexual intercourse is more than a means for procreation. It is a powerful expression of intimacy between human beings. It requires the shedding of all inhibitions and defenses to allow humans to explore each other in their most basic nakedness. Sexual intercourse may involve penile penetration, or a whole other spectrum of sexual acts that do not require penetration at all. Ultimately, it is the human being's choice whom to be intimate with and what that intimacy may involve. Rape is the violation of this choice. It is not punished simply because a penis forcefully penetrated a vagina. The crime is violent heinous because it takes away a victim's fundamental autonomy to choose with whom she would share intimacy. It violates a victim's autonomy over her own body. 87, underscoring supplied. However, despite the truth in the foregoing statements, I cannot agree to Justice Leonen's suggestion that the court should treat them equally, such that the court would apply the penalty prescribed by law for rape by sexual intercourse, that is, reclusion perpetua, to acts of rape by sexual assault. To do so would be an act of judicial legislation which, as I have stressed in this opinion many times, the court cannot do. Indeed, the country has gone far in terms of enacting legislations to provide special protection to women. Due to the enactment of RA 8353, the crime of rape has been reclassified from a crime against chastity to a crime against persons, thereby making the said crime a public crime. A new species of crimes called rape by sexual assault was also created by RA 8353 to expressly acknowledge that rape is nevertheless committed when the sexual acts were done without the victim's consent, even when the acts performed do not involve vaginal penetration by the penis. The acts constituting rape by sexual assault, either by a. inserting the penis into another person's mouth or anal orifice, or b. inserting an instrument or object into the genital or anal orifice of another person, through force, threat or intimidation. 88, were previously denominated as mere acts of lasciviousness and were thus upgraded to rape by the enactment of RA 8353. Another important development introduced by RA 8353 is the concept of marital rape, thus highlighting the significant paradigm shift in our rape laws to give premium to women's consent to sexual activities and thereby further upholding the autonomy of women. In recognition also of the fact that women are, more often than not, the victims of domestic violence, the legislature enacted RA 9262 to provide protection against women and their children from various forms of abuses committed against them by persons with whom they have or had a sexual or dating relationship. Deviating from the traditional definition of violence, which was limited to physical and sexual violence, RA 9262 expanded the definition to include other forms of violence, namely psychological and economic abuse. These legislations, to name a few, reflect an evolving understanding of consent, autonomy of women, and the role of laws in curbing patriarchal structures that perpetuate violence against women. In a similar way, it also reflects a progressive thrust towards protection of women. In this connection, I take exception to Justice Leonen's statement that, we cannot continue to convict rapists on the basis that women need to be kept chaste and virginal. 89. As shown above, the legislature had already taken steps in enacting legislation based on society's improving understanding of consent and female sexuality. Moreover, the court itself, in its numerous decisions, has taken strides in reversing outdated notions about these concepts. Examples of these include the following, where the court held that 1. A love affair does not justify rape, for the beloved cannot be sexually violated against her will. Love is not a license for lust. 90. 2. Husbands do not have property rights over their wives' bodies. Sexual intercourse, albeit within the realm of marriage, if not consensual, is rape. 91. 3. A victim should never be faulted for her lack of resistance to any forms of crime, particularly as grievous as rape. Failure to shout or offer tenacious resistance does not make voluntary the victim's submission to the perpetrator's lust. 92 and 4. Even a complainant who is a woman of loose morals could still be the victim of rape. Even a prostitute may be a victim of rape. 93. Respectfully, it would be inaccurate to claim that the legal framework on rape and sexual abuse, as crafted by the legislature and interpreted by the court, remains to be based on ancient mindsets and outdated notions. As illustrated by the foregoing, the different branches of government have been active, within the respective scopes of power granted to them by the Constitution, in reversing oppressive structures that perpetrate and perpetuate violence against women, particularly in the area of sexual violence. Apropos thereto, the legislature, in the exercise of its wisdom, enacted RA 8353 with a distinction between rape by penile penetration of the vagina as against acts considered as rape by sexual assault. To my mind, the distinction created by the legislature should be upheld in the absence of a clear and unmistakable showing that it is unconstitutional. It bears to stress that the power to declare something as a criminal act, and to prescribe the corresponding penalty therefore, is a power vested solely by the Constitution on the legislature, not on this court. Moreover, it is my considered opinion that the distinction is valid because rape by penile penetration of the vagina may result in an unwanted pregnancy which may subject the woman to a lifelong responsibility of rearing a child as a result of the dastardly act. The same cannot be said, however, for other acts of rape that are not committed through penile penetration of the vagina. In other words, the severity of punishment imposed on the crime of rape by sexual intercourse does not spring from the archaic notion that sexual intercourse is merely a reproductive activity. On the contrary, the distinction is based on the possibility that the victim might incur a perpetual responsibility, one that is not present in acts constituting rape by sexual assault. Thus, while the trauma faced by victims of either forms of abuse are conceitedly equal, victims of rape by sexual intercourse are subjected to another residual and permanent form of victimization, that is, pregnancy, to which victims of other forms of sexual abuse are not subjected. I thus disagree with Justice Leonen's statements that, the idea that one kind of rape is punished more severely than the other because of unwanted procreation only serves to undermine the law's reconceptualization of rape as a crime against persons. 94 and that providing a lesser punishment for the forceful insertion of a finger into the vagina, solely because it will not result in an unwanted pregnancy, is a step backwards. 95. To my mind, the difference in treatment is not based on an archaic notion about a woman's virtue, but has more to do with the possibility that, as a result of the act, the victim would be forced to introduce another life in this world, one that the woman victim would have responsibility over for the rest of her life. To reiterate, it may be true that all types of sexual abuse inflict the same amount of suffering or trauma, but only rape by penile penetration of the vagina could possibly impregnate the victim. This possibility is, to my mind, at the heart of the difference in terms of penalties to be imposed, not the perceived intensity of suffering caused on the victim. Stated differently, the difference in the penalties imposed was not meant to belittle the suffering of victims of rape by sexual assault, rather, it is meant to recognize that victims of rape by penile penetration of the vagina face risks that none of the other victims are subjected to. Therefore, I disagree with the assertion that, his court's continued refusal to recognize the forceful insertion of a finger into a woman's vagina as rape by sexual intercourse only shows that rape, at least in the eyes of this court, has remained a crime against chastity. 96 as not only suffering from a lack of factual basis, but also failing to recognize that this policy decision to treat the two crimes differently is within the province of the legislature to decide. It bears to stress that the power granted to the court by the Constitution is judicial power or the power to interpret what the law means in a specific set of facts. It is not the power to determine what the law should be. It is immaterial whether we, as individual justices, agree with the wisdom of the law, for our solemn power and duty to apply the same remains so long as the said law is constitutional. In the matter at hand, RA 8353 treats rape by penile penetration of the vagina differently from rape by sexual assault. While I join Justice Leonen on his call to not measure a woman's dignity on the sole basis of her virtue, 97, and to recognizes that all victims of forced sexual acts suffer the same indignity, 98, it is equally important for the court to recognize its place in our constitutional government, that it is but one of only three co-equal branches of the government, and it is not its task to set the corresponding penalties to be imposed on certain criminal acts. This is not to say that there is no merit in his point that our evolving understanding of human sexuality should lead us to treat both types of rape, bisexual intercourse and bisexual assault, equally. Sexual intercourse, indeed, is more than a means for procreation, and I also agree that rape, at its core, is essentially a violation of a person's choice on when and with whom to be physically intimate. The policy decision, however, lies not with the court but with Congress. A final note. At this juncture, I would like to again laud the Ponench's efforts to determine the intent of the legislature, including revisiting the Senate's deliberations, in enacting RA 7610. However, as our respective study of the deliberations yielded different results, I once again make the point that the language of a penal statute cannot be enlarged beyond the ordinary meaning of its terms in order to carry into effect the general purpose for which the statute was enacted. Only those persons, offenses, and penalties, clearly included, beyond any reasonable doubt, will be considered within the statute's operation. The fact alone that there are different interpretations as to the applicability of Section 5b should impel the court to construe the law strictly, with any reasonable doubt resolved in favor of the person charged. 99 As the court reminds in one case. The statute, then, being penal, must be construed with such strictness as to carefully safeguard the rights of the defendant and at the same time preserve the obvious intention of the legislature. If the language be plain, it will be construed as it reads, and the words of the statute given their full meaning. If ambiguous, the court will lean more strongly in favor of the defendant than it would if the statute were remedial. In both cases it will endeavor to effect substantial justice. XXX 100. Lest it be misconstrued, I am not stubbornly arguing for my position in this case in order that a guilty person may go scot-free. As the court in People v. Purisima 101 held, the purpose is not to enable a guilty person to escape punishment through a technicality but to provide a precise definition of forbidden acts. In the end, this opinion is only meant to pursue one thing, that is, so that justice can be properly dispensed not just to the minors victimized by sexual predators, but also to the latter who, even though they have violated the law, nevertheless have the right to be punished only to the extent of the specific punishment imposed on them by the law. Based on these premises, I vote to deny the instant appeal and affirm with modification the decision of the Court of Appeals dated August 17, 2015, as follows. The court finds accused appellant Salvador Tulagan guilty beyond reasonable doubt of sexual assault under paragraph 2, Article 266A of the Revised Penal Code, in criminal case No. SCC 6210, and is sentenced to suffer the indeterminate penalty of 4 years and 2 months of prison correctional, as minimum, to 10 years of prison mayor, as maximum. He is further ordered to pay AAA the amounts of P50,000.00 as civil indemnity, P50,000.00 as moral damages, and P50,000.00 as exemplary damages. Guilty beyond reasonable doubt of statutory rape under Article 266A1D and penalized in Article 266B of the Revised Penal Code, in criminal case No. SCC 6211, and is sentenced to suffer the penalty of reclusion perpetua with modification as to the award of damages. Appellant is ordered to pay AAA the amounts of P75,000.00 as civil indemnity, P75,000.00 as moral damages, and P75,000.00 as exemplary damages. Legal interest of 6% per annum is imposed on all damages awarded from the date of finality of this decision until fully paid. So ordered.